This is Paul Turner, the Immigration Barrister in Imperium Chambers. Please subscribe to my channel and hit the notification button for up-to-date immigration news. If you have a problem, please get in touch with me. Worrying news following on from the new proposals to deprive British citizens of their citizenship without giving them notice, as the Court of Appeal found that indefinite leave to remain can also be cancelled while the holder is outside the United Kingdom. This is potentially even more worrying as it arguably affects a lot of people and makes their immigration status precarious, to use the Home Office's term, when in my view they should be treated as residents and generally are treated as settled in the United Kingdom. This is a case that has potential consequences for a great number of migrants with ILR who thought that the United Kingdom, that their immigration problems rather were over, and some of them may have lived in the United Kingdom for 15, 20 years or so. Indeed, if anyone has any doubts about your status or how you obtained it, please feel free to get in touch with me before you leave the United Kingdom so you don't get caught out by this trap. Now, I'll explain the trap, or rather the law, and how it's been explained. It has been debated whether the Secretary of State did actually have the legal power to cancel somebody's indefinite leave to remain in such fashion when they're outside the United Kingdom. Well, in a recent decision, the Court of Appeal answered the question. Yes, the Secretary of State does have the power. In fact, the Secretary of State, the Home Secretary, has the legal power to cancel someone's indefinite leave to remain after all, the Court of Appeal has held. The importance of this is that the applicant, in what appears to be a national security case, had their indefinite leave to remain cancelled and an exclusion order was made, preventing them from re-entering the United Kingdom whilst they were outside the country. And that's what's particularly troubling. This all happened whilst the person was not in the UK, and arguably, and I'm not sure of the facts, were aware of what could happen. And therefore this has the potential to affect many other people. The basis for this law comes from, it's not very interesting, Article 13, subsection 7 of the Immigration Leave to Enter and Remain Order, which says where a person is outside the United Kingdom and has leave which is enforced by virtue of this article, that leave may be cancelled. So that gives the Secretary of State a general power to cancel leave. The issue was it just limited leave? And the case was argued that while limited leave could be cancelled under this provision, this did not cover indefinite leave to remain. Arguably so, given the importance that indefinite leave to remain carries. However, the Court of Appeal found otherwise. In this regard, what they did was they rolled back and looked at Section 3B of the 1971 Act, which conveys such a power, and Article 13, subsection 7 of the order, which permits the Secretary of State to cancel both limited and indefinite leave to remain. So, if you have any doubts whatsoever, you're unsure about your immigration status or how you acquired your indefinite leave to remain, or whether the government could be troublemaking, or there might be something in your past that you need to clear up, or you want to look at, then please get in touch with me and I'll do my best to advise you. But this is it's not from the government, it's from the court, but it is a case that has parallels with the proposals to deprive British citizens of their citizenship. Now, while citizenship is of a different level, indefinite leave to remain is, as we now know, far more precarious than we used to think that it was. Often people would not bother to become British citizens because they would just think that indefinite leave to remain carried with it the same benefits and not therefore bother to get themselves registered as British citizens. I suppose the one piece of advice I would take out of this is that if you do have indefinite leave to remain and you've had it for long enough and you qualify, then I would advise anyone to make an application to become a British citizen, because whilst there are these proposals to deprive British citizens of their citizenship, citizenship carries with it greater rights than having indefinite leave to remain, as we've seen from the recent case. I hope this video has been useful. I aim to bring you up to date new cases as they occur. This one's particularly important, and so I thought it merited a video. Thank you very much for watching my video. Please stay safe during the pandemic. It really isn't over. And having suffered from COVID, I know how unpleasant it is. And do please subscribe to my channel. And again, as I say, if you have any problem at all, you're curious about your immigration status, then just get in touch with me. Thank you again for watching. This is Paul Turner, the Immigration Barrister to Imperium Chambers.